Welcome to Self-Represented in Family Court, the only podcast you need if you're feeling lost, stuck, or overwhelmed in family court. At Self-Represented, we don't waste time discussing the law like all the other podcasts. We focus on what really matters in your divorce or custody case. That's strategy. With your host, Tracey Bee, former family law attorney turned pro se family court strategist.
So you've heard me say that leverage is incredibly important. It's critical in family court. One key element of having leverage or using leverage is timing. The way you time, the way you present, the way you use your leverage all matters. But we're going to specifically focus on timing. Timing is understanding when to file, because you can file too late, you can file too early. It means timing when you show your hand, because you can show too much too soon. You can not show enough in time. And it's also how you actually speak or show up in court, when you advocate more, when you speak assertively or aggressively. Timing that is very impactful. Timing is not just about when you think things should be done. You have to time every move you make in the context of your overall game plan, because a lot of people will sabotage your case just because they made a move, they made a decision that was either premature or too late. And that's one of the major things I get asked about every single day. Some timing errors will cost you money. They will cost you your peace of mind. They will cost you your child's future. I mean, the list is endless. But if you don't know what you're doing, if you don't understand the process, if you don't know how to identify and use leverage, you are prone to miscalculate your time. I often say to people, just because you could does not mean you should. And I see myself or hear myself saying that over and over again in family court, in family law topics and issues and scenarios. Because a lot of people, especially in custody battles, oftentimes the other parent, whether they be the non-custodial or the custodial parent, will violate court orders, parenting agreements, or they will do something that is totally outside of the customary practice, or they will do something that's atypical or a complete deviation or departure from what the routine has been up until this point. And oftentimes, what either parent will do as a result of that is run to court and try to get the judge involved to stop that behavior, or to change the behavior, or to remediate the issue that it created. And that's not necessarily the way to do things. It doesn't mean that they should be ignored completely. It means that timing when you bring these things up should be more of the go-to, more of the innate response or reaction, is actually mapping out when you would bring these issues up. There are usually other ways to address uncooperation or violations of a parenting agreement or a custody order. What that may be for you, it depends on the context of your overall situation. But running to file contempt or any other petition or motion as a result of the other parent's violative or uncooperative behavior can and often does backfire. Because, and as I always tell people, just because the option exists doesn't mean it's one that you should exercise right now. And I find myself getting a lot of resistance from parents when I suggest this to them until they've been in family court for a while and they filed several contempts, and they're realizing that filing contempts starts to be a futile effort, because they're not getting the response or the reaction from the judge that they anticipated. And so that is one of the major scenarios or circumstances where timing your filing is a great example of how it could be a waste of time. Not only that, it can actually make things worse for you. If you're continuously filing contempts, you're making the judge work more. You're pissing the judge off. Excuse my language. I remember being in front of a judge in Queens County, and I said that word, and he's like, "Counselor, such language." And I said, "What did I say?" And he said, "The P word." And I'm like, "No offense, Judge, my apologies. My generation didn't think we didn't consider that obscene language. So I apologize if I offended any of you, including you, Judge, by using that word." But a lot of judges really get rubbed the wrong way when you're filing continuous contempts, especially when it comes to issues regarding co-parenting. Because I often say this too, co-parenting or lack thereof are not typical issues you bring to the court. But that's another topic. Back to timing. So what do? You time your presenting these issues to the court. There are ways that you can get those issues or bring this stuff to the court's attention without being the one to file incessant motions or petitions to get a reaction or to get a response from the judge. Your timing, though, is going to be critical in this situation, because you don't want what you have now to backfire. You don't want to numb the judge to your issues. You don't want the judge to exercise compassion fatigue about concerns you have about your child and their other parent, or how they're raising your child, or how they're not raising your child when the child is in their possession or in their custody or in their home. You have to be strategic about when you bring this up. Not just how, but when. Because if you bring this up at the first sign of uncooperation or violation or deviation from the norm or the standard or routine, and your case is literally just getting started, what recourse will you have? Because it will intensify. What recourse will you have as those behaviors intensify down the line? Especially if you bring them up to the judge early on and the judge saw no reason. Some people think it sets a precedence, it sets a tone if you bring it up early on, so the judge will be mindful of it and the judge can move accordingly. The judge will make rulings based on you bringing up these infractions early on. And sometimes that is the case. And so sometimes you need to use discernment to think about if that's going to be your strategy. But again, that decision needs to be made in context. That decision needs to be made in light of what the issues are, who the parties are, if there's attorneys involved, who your judge is, the complexity, the background issue. You need to make that decision in context. But timing is going to be something you absolutely need to consider and factor in. Let's talk about some other scenarios where timing is key. Oftentimes, in scenarios where there was financial abuse or control or manipulation before the divorce, during the marriage, it spills over into the divorce action where the moneyed spouse or the controlling spouse or the manipulative spouse does not want to provide financial information as per most court rules. When you're starting a divorce in every state in this country, you have to provide financial disclosures, financial information to the other party and to the court. Well, sometimes, a lot of times, the controlling spouse, the manipulative spouse, will avoid turning over those documents as long as they possibly can. And if they do, a lot of them don't provide all the information. They don't disclose all the details like they're supposed to. This happens often. So what I get asked a lot is, well, what do I do? Because I've been asking for these documents. My attorney's been asking for these documents from the other party for months. They were supposed to turn them over 3 months ago. They still haven't. Or they've turned them over, but they're lying about, the information they've provided, the data, the details they provided or not provided. We need those details. So what do I do? Should I let the judge know that now because it's so early on in the case and we really shouldn't be moving forward without that information? Or should I wait until things get, much more heated, we get into the thick of things and we get to the point where it really, a settlement or anything moving forward hinges on me having this information? What should I do? When should I actually push for this? And that's really important to know, because in the front end, if you are really thinking about negotiations or mediations, any sort of settlement, then you really want that financial disclosure. But if they're not providing it willingly, what do? Do you file a motion, or do you just wait it out? Do you just push back any settlement discussions, any meaningful settlement discussions, until that has been provided? Or do you proceed through mediation and actually get on the court track? And at some point down the line, when things really get in the thick of it, do you file a motion, or you let the judge know then? So timing that is going to be key, because you can't really you shouldn't really try to make any sort of proposals or come to any sort of resolutions or settlements where there's financial assets involved or any financial support involved if you don't have full disclosure of the financial predicament of the other party. You really shouldn't. Then you'd be making decisions blindly, and I'm not a fan of that. But if you file a motion now, what are the chances that the judge may actually compel them to? Will the other party take that as a sign of you not wanting to resolve this amicably or peacefully or civilly or as low conflict as possible because you actually went that route to file a motion? So again, it's a matter of timing. And timing is a part of leverage. Leverage is a key component in strategy. And so timing, when you actually really push back about the lack of full disclosure, it should be incorporated into your overall strategy. What is your long-term goal? What are you trying to accomplish here? And I often ask this of people who come to me and say, well, I don't know what I should do at this point. Should I push it, or should I just wait down the line and be more aggressive down the lines as part of my strategy? I need to understand. And again, your overall strategy is yours. No two strategies are alike. So what you do is going to be entirely dependent upon the issues, your objectives, all the key components that have a role in how your case proceeds. But the bottom line is timing is critical. Timing is going to be critical in that scenario as well. How about seeking to modify custody? Should you try to modify custody now, or should you wait until things change in your favor? Should you do it now because you anticipate things getting worse in the other party's favor? Should you do it now because you know that in the future, if you wait longer, there might be a different judge or the attorneys might be different? Because all of these elements actually matter. They're going to have a critical, significant impact on how your case proceeds. Not just the outcome, but how it proceeds through the process. And so timing when you file a modification of custody should be given that much thought. And if you hadn't thought about all of that I just mentioned, then you should. Filing modification of custody should not, in most cases, should not be done in a vacuum just because you think it's a great time to do it. And if you don't know if this is whether or how you should time when to file, you need to talk to somebody like myself who will help you create a strategy based on what your overall objectives are. Because the key is planning, yes, but actually preparing and positioning is much more important than just planning. You can plan all day long. If you're not positioning at the same time, all your planning will fall flat. And part of that positioning is actually incorporating, examining, assessing timing. How about going pro se? There's this thing where I tell people, a lot of people think going pro se or being pro se is something that they have to commit to. When I suggest to people that they do some things pro se, sometimes I tell them to do pro se maybe just to start the case off, or when they're in between hearings and not much is happening and they can handle some of the out-of-court stuff. Being pro se is not a commitment. You don't have to be pro se from beginning to the end, from filing to finding. It's not mandatory. Sometimes being pro se should be part of your strategy. And timing when to do that is also key, especially if the other party has an attorney, or if it's just part of your key strategy. Because being pro se at some point will afford you the opportunity to forego some of the extra legal costs that the court would impose upon you because you are represented by an attorney. They assume you have the resources to pay for these additional resources. So you see, timing when you actually choose to be, and yes, some people do choose to be pro se because it's part of their strategy, that's going to be key. That's going to determine how your case moves along. That's going to determine the experience you have, whether you find it much more traumatizing or stressful, or it's never smooth sailing. But you get my drift. How about settling too early? I briefly touched upon that. Sometimes people settle too early, and it's for various reasons. Sometimes I suggest people settle early. If you're pro se, or if you don't have the resources to hire an attorney and your issues in your case are complex, or you're in a high conflict situation and you don't have the wherewithal to be pro se, and you don't have the resources to hire an attorney, and you can't get pro bono don't exist. Sometimes I will recommend to people that they actually settle their case. And sometimes, yes, that's prematurely. And sometimes, yes, that is strategic. That is being strategic. Because sometimes when you settle the case early on, you don't reveal a lot of what you're actually documenting, the proof you're building and gathering and collecting. So when you are in a position or in a situation where you can hire an attorney, or you are able to self-represent. So sometimes, yes, I do suggest to people that they self-represent, but timing that, when to settle, it's going to be different for everybody. Because sometimes you can settle too early and there's no recourse if you do that. You can't go back later and try to undo what's been done. If you settle too early on alimony, for example, or a financial settlement, you can't go back later and change that order. Most cases you can't, just because you found out what they truly have with respect to their net worth, the other party, the paying spouse's net worth. There are some situations where you can. That's another topic for another day, for another episode. But for the most part, in situations like that, once you're done, once you've settled, once you've agreed, you're pretty much, and I get that asked quite a bit too. Hey, if I settle this custody thing, can it change later? Yes, it can change later. You can settle that, you can resolve that now. And in the meantime, you can work on positioning yourself so that you can go back and seek a modification later on. So yeah, settling too early can be detrimental, but there are times when it's actually beneficial. So why do judges care about timing? Judges care about timing because they're evaluating stability, they're evaluating procedure, they're looking at what has already happened, not just while this case is pending, if you've been in court prior. They're looking at the patterns, they're looking at the background, they're looking at supporting or non-supporting. So they're looking at all these things because it's going to help them be able to make decisions a lot quicker. They need tools, they need points of references that's going to help them make decisions easier or smoother or much more economical, efficient for them, because they're overwhelmed, they're overworked, and so they need something, some system to help them make decisions quicker. So timing, your timing of filing, your timing of presenting, your timing of advocating, your timing of being pro se, your timing in most respects is actually plays into the systems they use to evaluate, to make decisions, to make rulings. So it cannot be ignored, it can't be minimized or dismissed. It impacts the judge and the courts in a way that it's going to affect the overall outcome and the process, of course, but the overall outcome of your case. So, what questions should you be asking yourself when it comes to, am I timing? Am I maximizing the timing? Am I using the timing? Am I incorporating timing? What stage is your case in? That's always going to be something important you need to consider. What narrative am I building? What narrative are you presenting to the court? And what precedent am I setting? What precedent am I setting to this court? What precedent am I setting to the overall case, to the opposing party, to the opposing counsel, to the key players? What precedent? Because how you're perceived, how credible you're perceived, how reliable you're perceived, how consistent you're perceived, again, is going to affect not just the outcome, but the process, the experience, the journey you have as your case moves through court. And how does this fit into my leverage? How does the timing fit into my leverage? Do I really have leverage? And if so, how does the timing of what I am intending to file, what I'm intending to say, what I'm intending to reveal, how does it fit into my overall leverage? So, if this was helpful to you in any way, please let me know. Share your thoughts. Did you make a decision or a move that was off, that you filed too prematurely, that you waited too long? And how did that work out for you? I'd really love to know. But if you want to discuss timing something in your case, whatever it is, let's talk. Schedule a strategy session. I'm always available during the week to talk to you. Let's take an hour. Let's go through what you have, and let's figure out what your strategy should be. Let's identify that leverage. Let's work on timing your next move. Until next time, thank you so much for tuning in. Take care.
If you're having an active family court case and something already feels off, you need to identify where your case is seriously exposed. Schedule a strategy session now so we can shield your case from more damage. You can't afford to keep guessing. It's costing you way too much.